They tried to fine me for my neighbor's yard. The first letter looked like a mistake. It was an HOA violation notice, the usual bold header and polite but threatening language, except the address listed under offending property condition wasn't mine. It was my neighbor's. Specifically, it cited excessive leaf accumulation, unmanaged vegetation, and visible weeds in the yard next door, the one separated from mine, by a perfectly ordinary wooden fence. At the bottom, however, was my name, and a fine. I assumed it was clerical. I walked it over to the HOA office the next morning and handed it to the property manager. "You've got the wrong house," I said. She glanced at it and shook her head. "No, this is correct." I waited for the explanation. "Because the properties share a border," she continued as if reciting something rehearsed, "you're responsible for ensuring that adjacent conditions don't negatively impact community standards." I blinked. "You want me to maintain someone else's yard?" "You're responsible for mitigating the visual impact," she clarified. "That yard belongs to a man I've spoken to twice in 5 years," I said. "I can't even get his Wi-Fi password." "And you expect me to landscape his property?" She smiled in that thin HOA way that means policy matters more than reality. "The fines will continue until the issue is corrected." I went home thinking it would sort itself out. It didn't. The next notice doubled the fine. No, not specifically. We assumed authority. We didn't believe notice was required. At one point, the judge removed his glasses and set them down, a gesture that somehow carried more weight than raising his voice ever could. "An HOA," he said slowly, "is not a government. It is not law enforcement, and it most certainly is not entitled to ignore trespass statutes, because leaves are unsightly." My attorney didn't add anything further. He didn't need to. The ruling came from the bench. "All fines issued to the defendant are vacated immediately," the judge said. "The association is ordered to cease any attempt to compel maintenance of property not owned by the defendant. Furthermore," he paused, glancing again at the photographs, "the court finds that the association's actions constituted unlawful entry for the purpose of enforcement. As such, sanctions are appropriate." The HOA attorney started to object, but the judge raised a hand. "You wanted the court involved," he said. "Now it is." He ordered the HOA to pay my legal costs. He issued a formal admonishment regarding future inspections. Any entry onto private property without written consent, he warned, would be treated as a matter for civil liability, or worse. Then he closed the file. Outside the courtroom, the HOA representatives walked past without making eye contact. The confidence they'd carried in had evaporated somewhere between the word trespass and the judge's ruling. My neighbor still doesn't rake his leaves, and now neither does anyone from the HOA. There was no good answer to that. The HOA pivoted. They began talking about shared visual corridors, community impact zones, and other phrases that sounded impressive but meant very little. Outside of a boardroom, they argued that because the yards touched, responsibility extended across the boundary. My attorney stood when it was his turn. "Your Honor," he said, walking to the evidence screen, "this is the property survey." He pulled up a clean, unmistakable diagram showing 2 lots, one fence and a very clear dividing line. "This line," he said, tapping the screen, "is called a boundary. It is recognized by the county, by the state, and, last I checked, by the law." A few quiet chuckles rippled through the courtroom. He clicked to the next image, one of the HOA's own photographs. This picture was taken approximately 12 feet inside the neighboring property. You can see the shadow of the photographer standing past the fence line. "That's not inspection. That's entry." He paused. "And this," he added, holding up the fine notices, "is what they did with that unlawful entry. They attempted to compel my client to perform maintenance on land he does not own, does not control, and is legally prohibited from altering." The judge leaned back slightly, fingers steepled. "Let me understand the practical outcome of your argument," he said to the HOA. "If one homeowner refuses to rake leaves, you can simply deputize the neighbor and start issuing penalties?" The HOA attorney hesitated. "In effect, yes, to preserve standards." The judge blinked once. "That is not how property law works," he said. The shift in the room was immediate. What had started as a dispute over landscaping now clearly wasn't. The judge began asking questions the HOA had not prepared for. Who authorized the entry? Had they done this before? What training did board members receive regarding legal access? Did they notify the actual property owner they had stepped onto his land? Each answer was worse than the last. How were these photographs obtained? The HOA's attorney stood up, confident. One hand resting on the table like this was just another procedural step. "Your Honor, the association conducted a Routine compliance inspection consistent with its governing authority. The judge didn't look up from the photograph he was holding. From where? He repeated. There was a pause, small, but long enough for everyone in the room to notice. The HOA representative, a board member named Talbot, leaned toward the microphone. We accessed the adjacent lot to document the violation, he said. The judge finally looked up. Accessed, he repeated. That's an interesting choice of word. Did you have permission to enter that property? Talbot shifted in his chair. The bylaws allow the association to take reasonable steps to enforce. That wasn't my question, the judge said, calm but unmistakably firm. Did you have permission from the property owner? No, Talbot admitted. My attorney didn't even try to hide his smile. The judge set the photograph down carefully, like it had suddenly become evidence of something far more serious than yard debris. So, he continued, you entered private property without consent, took photographs, and then used those photographs to fine a third party who doesn't even own that property. The HOA attorney tried to recover. Your Honor, the association has a duty to maintain community aesthetics. The neighboring homeowners, failure to address the condition created, a visible nuisance impacting the defendant's lot. The judge raised an eyebrow. So your solution was to trespass? Then another arrived, citing continued noncompliance. The amounts escalated fast, daily penalties stacked on top of administrative fees, inspection charges, and something called a neighborhood preservation assessment. I tried talking to my neighbor. He was elderly, didn't care about leaves, and certainly hadn't authorized me or anyone else to step onto his property. Tell them to mind their business, he said and went back inside. I relayed that message. The HOA didn't appreciate it. Instead, they sent photographic evidence, printed in color, multiple angles, close-ups, wide shots, all clearly taken from inside my neighbor's yard. That was the moment the situation changed from absurd to actionable, because there was only one way to get those pictures. They had gone onto private property without permission. I hired an attorney. He studied the notices, the fines, and finally the photos. He spent a long moment looking at one image, where the photographer had clearly stood several feet past the fence line. Then he looked at me and said, well, they just lost. The HOA filed to enforce the fines anyway. I convinced their authority would carry the day. They argued in court that maintaining community appearance justified their actions and that adjacent homeowners shared derivative responsibility. The judge let them finish. Then he asked a simple question.